So, Renato, was there any teeth to the legal strategy that Trump's lawyers cooked up before January 6th?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet.
So, Renato, we got another little tidbit in the January 6th case recently, which was one of the memos that Trump's lawyers presented to him, outlining the legal strategy that would get him across the finish line on January 6th. And this one is written by Ken Chesebro. And I have to say, like, only in this saga can there be a guy with last name Chesebro, but okay.
It's not Chesebro. It's actually Chesebro.
Oh, is it Chesebro? Because I
don't know. I don't know. Okay, let's keep going. It looks like Chesebro.
I've been saying, can we say Chesebro? You want to
sure?
Say
why not?
I don't know.
Why not?
Chesebro like seems more appropriate, to be honest. And he is, I believe, co-conspirator 5.
Mm-hmm.
Yeah,
that's right.
If you're following along in the indictment, he's co-conspirator 5. In fact, let's review who the co-conspirators are. Co-conspirator 1 is Rudy Giuliani. Co-conspirator 2 is John Eastman. Co-conspirator 3 is Sidney Powell. Sidney Powell. The Kraken. Co-conspirator 4 is Jeffrey Clark. Co-conspirator 5 is Ken Chesebro. And I don't think we know exactly who co-conspirator 6 is. Is that correct?
Yeah, isn't that like a political strategist? And so
it's a political strategist, and I mean, I thought it could be Roger Stone or Steve Bannon, maybe, but
yeah, I've heard arguments that it's Steve Bannon. Some people suggested like Miller, but he seemed like he's like testifying with the January 6th committee and stuff. I doubt it.
Yeah. Anyway, did you see any significant differences between this new memo, and I think it's referred to as the Wisconsin Memo in the indictment, I believe. Any big difference between this and the general legal strategy that was presented by John Eastman, who also wrote, I think, a 2-page memo on how this was all going to unfold once these fake slates of electors got presented to Congress? This is almost sort of like the preliminary to lead up. This is like part 1, and I guess John Eastman's was sort of like maybe a part 2, but I don't know how you think about it.
Yeah, Eastman was further down the line. I mean, it's interesting when you read Ken Chesebro's memo. One thing I'll just say, because we actually got some comments. We do read your comments and all the feedback that we get from all of you. And I know some of you are like, please explain this memo on the next episode. So we've heard you. This is not a typical legal memo or anything that you would deliver to a client. I'll just say that as somebody who delivers legal advice to clients every day. Like, it's bizarre. And part of it is, I would say this is early on. One thing I'll just note, it's early on. He doesn't really know a lot of the facts yet. He's basically like, look, if we don't concede the election, we need to do all these different things. We're going to file lawsuits everywhere. We're going to delay the vote. We're going to try to focus attention on these issues. There's a sense to which, and I think this was something you had mentioned, Asha, one of your initial impressions, it's not entirely a legal strategy. There's a PR or political element to all of it. But it's definitely earlier in time. The point I'm trying to make is Eastman, I feel like, was making a lot of recommendations when everyone realized there was no hope. John Eastman, it's like Obi-Wan Kenobi. John Eastman was the only hope or whatever at that point. Chesebro was like earlier on, he's like, hey, maybe we can have some successful lawsuits. Maybe this could happen or that could happen. But here's the general strategy. Like, let me lay out sort of what this looks like. I don't necessarily recommend it. I'm not necessarily advising you do it, but here's the general overall strategy of what one could do if one wanted to try to overthrow the election.
Yeah, so great point in terms of the timeline. So this memo is written on December 6th, 2020. And as you mentioned, I think John Eastman's is later, but December 6th is 8 days before electors in states had to vote and certify their electoral results. And so just a summary for those people who haven't read the memo, though we can include a link, I think, when we post the podcast. This is basically laying out, as Renato just said, that assuming that the Trump-Pence campaign doesn't concede, how to set the stage so that Trump can still win with 270 electoral votes. And basically what he's outlining is a strategy where electors in 6 states are going to meet and vote for Trump and Pence, that his electors are going to meet and vote. And if you're following along on my self-coup chart, those 6 states are listed at the bottom. And importantly, that the way to do this, the way to allow for these electors to meet and vote for Trump, even though he didn't win, was to make sure that there was pending litigation occurring in all 6 of those states so that they could point to something that says, hey, look, this is still contested. This is still up in the air. We don't really know what the votes are, so we're just creating this backup option. And to your point, Renato, I would not call it a PR strategy. To me, this is an information warfare strategy. This is a way of shaping the perception around the election in order to create a space where going down this road appears to be legitimate, even when they know. I mean, he's not actually pointing to any basis for litigation, real basis. He's just saying we just need to have litigation in place, whatever the case may be. And we know that they later filed frivolous lawsuits for precisely this reason.
Yeah, that's a very smart point, Asha. I agree with that. I think that one thing that underlies the entire memo is using the processes of government to manipulate the appearance of the situation. So stop, one of the telling lines we see, like, stop the vote. Essentially, you have Pence try to stop the vote at a point where we're ahead in the count, so that this way, when we go to the Supreme Court, it looks like we're ahead. And it's purely like, have the vice president manipulate the entire process on January 6th in terms of the counting electoral votes in order to create some false appearance that we're in the lead when, of course, we've lost. And so I think that, he does, in a number of points, he says, for example, we need to at least keep our options open. Essentially, we need to have these fake electors file. Essentially, he doesn't really have any knowledge of fraud. He's not outlining some strategy to legal argument that's going to change the outcome. It's about, I agree, it's about creating the appearance that there's some legitimate question about the election. And he basically talks a lot about trying to focus attention on issues. The reason I say that that's not a typical legal memo, I want to just make sure our listeners understand this and viewers understand this, because it's I think an important distinction. Lawyers generally are not supposed to and don't draw up legal plans and lawsuits just to sort of change narratives. Like you're not supposed to. I understand Donald Trump files lawsuits to get people to write stories about them, but that's actually an abuse of the legal process. So even if there was a memo like, hey, I don't advise this, but you could file a lawsuit just to make someone look bad, that's actually a no-no. As a lawyer, this goes way beyond that. Like, this is like, let's totally screw with the confidence that the American people have in our system of government and try to use various pain points to, kind of poke at and create issues to highlight the um, perhaps ambiguities in the transfer of power in order to sow doubt, in order to change the outcome of the election and overturn the election.
Yeah, it's using courts as propaganda. And there's actually a specific term for this. It's called legitimizing propaganda. So, legitimizing propaganda is where you have some third party or entity which has a lot of credibility put out a message or create a message that then you can point to as corroborating your false narrative.
Is this
So,
like the Jim Jordan committee that puts out like little sound? It's like there's a congressional witness saying this. Fox News talking point.
yeah. I mean, it is that exactly. I would say the best example that I would use about this is the Ukraine phone call. That when Trump asked Zelensky on the down low to announce an investigation into the Bidens, what he wanted, and remember, he didn't ask for him to initiate an investigation. He just wanted him to announce one on CNN. Because once Ukraine, random other country, not the United States, says, hey, we believe these, Joe and Hunter Biden are corrupt, then the Trump campaign could say, see, look, we were right. He's being investigated there. We should be investigating him here or something like that. And so in similar way, what Chesebro is saying here is let's get these, lawsuits started because that will provide corroboration through the court system that what we're doing is necessary and based on fact. And and he goes even further. If you look in the memo, he literally has a talking point, or he literally has an outline point that says, number 2, messaging about the December 14th vote as routine. In other words, not only did he want to present the meeting and voting of these alternate slates of electors as, legally justified, he wanted to send the message to the public that this is routine, this is what we do. And he then enlists, kind of cherry picks a bunch of, dicta from court decisions like Bush v. Gore. He miscites Professor Larry Tribe, saying that, that this is how it should work if things are completely still unresolved.
Yeah, I mean, that portion of it almost read to me where he's going through all these sort of, in his mind, liberals who are writing op-eds and so on. It's like justifying what we're doing. Like, by this point in the memo, you read it, you're like, he's concerned that someone reading is like, wow, that's really evil. Okay. It's so, here's our justification for why we're doing it. And it's because they do it or they're advocating for it. And it's interesting if so I did read a little bit of Professor Tribe's, he's very upset about this.
Yeah.
His words on it. And basically, apparently Chesebro at one point was a research assistant of his and sort of twisted his basically, that's how he learned about, all of the details of the Electoral Count Act and all of this back in 2000 during the Bush versus Gore era. And he's twisted in Professor Tribe's view, his words. I mean, to me, to me, that's the least egregious part of it. To me, what is just astounding is you have a lawyer saying, I don't really have any legal basis to file a lawsuit. I don't even know what we're vindicating here because I don't even know that you've been harmed in any way. But here is a way of sowing great harm to the United States of America. I'm not saying you do it, but here's my roadmap. Do what you're going to do. It's just very dangerous. It would be like essentially, if I was telling a client of mine, like, hey, I don't know whether the prosecutor's done anything wrong to you, but here's all sorts of ways you could totally F with his life. Like, here's a bunch of ways to do it. I'm not saying you should, but here's how you could do it. Here's all these like tricks that I understand because I'm a lawyer of how you can make this guy's life a living hell. And why are but I'm not saying I'm not necessarily advising you do that. It's a very bold and controversial idea to do this.
Yeah, I mean, you summed it up well earlier, where this is essentially a plan to undermine American voters' faith in the legitimacy of our election when there was no reason to doubt the outcome of the election. And that's the key point here. And what we know is that, their attempts from the indictment, we know that their attempts to get officials in these different states to provide more corroboration, to provide more legitimizing propaganda, that they had found fraud or that they were relooking at it. Those people refused to do it on grounds that they were not going to violate their oaths, that they weren't going to make stuff up. So this was really, I think where it gets hard is, if there was actually a legitimate basis to go to court, that would be an okay use of the court system. It's the fact that these were fabricated cases. And I just want to add, by the way, he doesn't say this in this memo, but remember that the end game also involved the Supreme Court finally providing the ultimate legitimizing propaganda, which was what John Eastman hoped was that when it went to the Supreme Court, after all of this crazy goes down and there's all these different slates of electors that are up in the air, he believed that at least Justice Thomas would be willing to sign on to his whole independent state legislature theory, but that even if the other justices weren't, that ultimately they would punt on even ruling on it because they would determine that this was a political question, something that the courts don't get involved in and don't answer, and that they would just kick it back to Congress and the executive branch to figure out, which would have resulted in, had Pence gone along with this, in Pence executing the plan that Eastman concocted.
Correct. And I mean, there is an element here where he thinks that, it's because it's much earlier on, as I mentioned in the beginning, he thinks the Supreme Court might be involved, and he talks about how to manipulate that, but it's too early because he doesn't even have any legal, there's no viable legal theory in his mind of getting to the Supreme Court. He's at an earlier stage.
Well, that's where John Eastman comes in with this whole independent state legislature thing.
Exactly. One thing I will say before we turn to the next segment is, a lot of people are like, okay, is this guy going to prison or what's going on? It'll be interesting to see what Smith does with all of these crooked lawyers like Chesebro or Chesebro. What I will say is that as somebody who has prosecuted and convicted lawyers, it's like not easy to do. They usually use these weasel words like Chesebro does, and they usually are not stupid enough to write down their crooked plans on a sheet of paper. But it's certainly possible, but it's much more challenging than like some of the stuff that Smith has already taken on, because they're basically he's going to claim like, look, this guy asked me for advice and interpret laws. I'm just giving him ideas. I'm not even advocating for them. Like, I'm just telling him, here are my thoughts. Is that a crime? Is like a thought crime? That's how I'm not saying that's right. I'm just explaining that is the argument that he will give and that Smith would have to overcome.
Yeah. And I just want to add on to that I think one of the challenges we have in the Trump era is how much is being said out loud. Like you said, this memo is put in black and white. And in fact, even as Chesebro is saying that we should have these alternate slates of electors meet and vote for Trump and Pence, he's actually not advocating that they do it in secret. He thinks they should do it in private because he doesn't want them to be disrupted. But he's like, we could invite the media. And in other words, there is a way in which they want to put a spotlight on it. And at the time, this was actually being reported and we knew about it. And I think there's always been this challenge that if people are doing things out in the open, that it can't be criminal. I mean, we found this with Trump. Like, he would confess to obstruction on Twitter, and it would be like, well, obviously that can't be, a crime because he basically said he did it. But they do. And the fact that it's put on paper or articulated or reported or tweeted does not mean that it's not criminal. But we have in our minds that people only do commit crimes like in secret, and they try to hide it all.
Yeah, I think that's right. And I just think with lawyers, he's using as a protection, right? The
Mm-hmm.
fact that I'm a lawyer and I'm just giving legal advice and so forth. It's really not legal advice, but it's under the guise of giving legal advice. It's almost, it's perverting the legal profession. It's using the knowledge you have as a lawyer to try to advise someone to do something that is not really legal advice at all.
And Harold Coe, our former civil procedure professor and later dean of Yale Law School, always would tell incoming students, never let your skill exceed your virtue. And I would say that's exactly what these lawyers were doing here.
Indeed. So, Asha, a lot has been going on in the federal cases. I think that we can, there's other cases out there too, of course, and other developments because Trump's got so many issues. But I think in the January 6th case, there have been a number of recent developments, and there was a recent development in Mar-a-Lago. But maybe let's talk about January 6th first. I know we gave our initial reactions, but you and I have been talking a lot, I think, back and forth about. I think our thoughts of how this is going to play out, especially since a number of the co-conspirators haven't even been indicted yet.
Yeah, what do you make of that?
It's a great question. I think I think one thing I would say is a few things. Typically, if you would indict everyone you're going to indict up front, you'd indict them in one indictment for a couple of reasons. One is having defendants who have different positions on things in the same trial is generally good for the prosecution because they point fingers at each other. If their stories don't match up, then the jury is going to just discount all of them. Plus, it helps from an evidentiary perspective because even though the jury gets warned that, let's say, a particular document is only coming in as against Eastman, it's not like they can unhear it, and so they're going to see all the evidence. I'm just being very real about how this all plays out at a trial. So prosecutors love joint trials. Judges love joint trials because then they try one case instead of 3 or 4 or 5. So everybody loves the joint trial other than the defense. I presumed that Smith had kind of split off Trump from the others to just make this go faster. I think we may have talked about that previously. But I think an open question is, will he indict all of these folks? Because Trump's got a number of defenses. In this case, it's going to be more of a challenge for Smith than the Mar-a-Lago case was purely on the evidence. And then, these other co-conspirators, they're in a different spot. We just talked about Chesebro. He's going to say, look, I'm a lawyer who wrote a memo. I'm not out there, inciting insurrections or doing anything crazy. I just wrote a memo. That's the way he's going to present it. I'm not saying that that's the truth, but that's how that's going to be his argument. And so it's a different kind of case for Smith to take on. And, he has to really decide for himself, like how much energy and resources does he really want to spend going after this whole sort of, crooked group.
But he brings them in and identifies them as co-conspirators, presumably to increase pressure on them to cooperate. I mean, he's sending the signal that they are in danger of criminal liability, right? Like he doesn't, because he could have just identified them as a lawyer otherwise, if he didn't believe that they were a part of a criminal scheme.
Correct. There's no question that he thinks they're part of the conspiracy. The question is whether he wants to take on proving it beyond a reasonable doubt. Okay, we'll make a bold prediction. I'll put something out there. If there's anyone who's charged, the one who's most likely to be charged, and I think their signs are pointing to yes, like Magic 8 Ball, it's Rudy Giuliani. Bernie Kerik, it seems like he has a lot to say to the prosecutors. This is a guy who's already been to prison, if I recall correctly, got pardoned. I think he doesn't really want to go to prison again. He's old enough where maybe, that's a substantial portion of his remaining life. I wouldn't be surprised if Smith is working towards a Giuliani prosecution because Giuliani is a mess. He can't take the stand. He's said all sorts of crazy things. He's basically like, a worse version of Trump. I mean, from a defense perspective, he has none of the upside and all the downside. The question, I think it's harder, whether he takes on someone like Chesebro, whatever, Clark or Eastman or some of them. I think Eastman is the most likely of the group. It would be the one I would be take on of that crew. But even there, Eastman is a more rational actor than either Trump or Giuliani. Like, he's not going to do crazy things like just go on Twitter and just start, giving, or whatever it's called that nowadays, and just
So
giving his
there are
thoughts.
interviews of him that have surfaced where he's very clearly saying that the exact legal theory that he later promoted is not a thing. So
well,
there's
maybe
that.
I'm overspeaking that.
Yeah.
Okay.
So I think let's remember that Eastman and Clark were originally in the crosshairs of the Justice Department well before they decided to actually go after Trump. And so I think for sure that Smith will go after Eastman. And I think he has to go after Clark because Clark was acting as an official, as a government official, and as a, he was in the Justice Department.
Mm-hmm.
I cannot see how you let this man go when he was willing, and his conduct was, there wasn't even the pretext of real legal advice. Like, he literally made up a letter that he wanted to send to Georgia. Again, going back to the concept of legitimizing propaganda, telling Georgia that the Justice Department had found evidence of voter fraud when it had not. And telling them that they were authorized to interfering in their state, matters. I mean, it was crazy. That whole letter was crazy. And I believe that just as a matter of example, and morale for the rest of the Justice Department, he would have to go after him.
Yeah, I mean, I don't disagree. I would charge Clark myself as well, but it's not going to be as easy. If I was charging Clark, honestly, I would consider having a much more streamlined indictment. I would go after, if I was going to go after Clark, I would almost consider 1,001 count.
I was just about to say, false statement seems pretty, if they're in black and white.
You got him on that. You got him on the false statement because he wrote this letter saying we have these investigations and there's allegations of voter fraud and you should consider pausing your thing. Your electoral certification process in Georgia. And he was told by the Attorney General and others at the Justice Department, acting Attorney General and others at the Justice Department, that the investigation was over. They had found nothing of any substance. This was outside the bounds of what the Justice Department should do. And he had no authority to do it. And he was doing, catching this plot anyway. Like, that to me is super straightforward and narrow, and just that's a straight up easy trial. What I'm referring to is the issue for Smith is he's kind of committed himself that these people were all part of the grand conspiracy. And so if he's going to model that and have some, let's say, separate indictment where he lays out the same grand conspiracy and throws them all in it, then he's taking on a lot. And it's just a lot of energy and resources and attention focused to a trial that is not the main event. That's the undercard.
Well, why can't he wait until, he has until, that was what, 2020? Yeah, he has until after the election.
Sure. Of course. Theoretically, yes. But I think theoretically, yes, he does.
He could even hand it back to the Justice Department at that point and say, here's my report. I got approval to prosecute Donald Trump. I'm handing this back. Here's kind of like what Mueller did. Here's all the evidence that I've gathered. And these are, the conflict of interest is no longer there anymore. So you guys decide what to do. And then it's up to Garland between whenever the Trump trial ends and, the new administration is sworn in, which could be a Trump administration, to decide what to do.
Yeah, Jeffrey Clark could be the Attorney General. He's, I think, according to, Jonathan Swan and some of these people who have good sources in the Trump world, he's the favorite to be Attorney General in the next administration. Yeah, I think another possibility, you're saying to wait, is that he's waiting to see if his evidence gets better, right? In other words, now more people are coming in. They don't want to be included in the next indictment. And frankly, he'll get more evidence in a Trump trial, okay? Because he's going to get Trump potentially, maybe Trump will take the stand. Certainly some associates may take the stand. So there's that element as well. I mean, I think that's interesting, but the bottom line, just from a very high level, is there are more defenses here, and I don't want I don't want a lot of angry comments here. That's just the reality is Smith is doing something that's pretty unprecedented here. He's making this charges that have never really been brought in this way before because the conduct has never been done before. It's so unusual, right? It's not like, people, you can go on the DOJ website and you will find cases where federal employees and contractors keep documents after they leave. They get charged with willful retention and they plead guilty. That's like pretty standard. There's lots of cases where people delete video and try to hide documents from the government. Those people get charged. Like, you can look those cases up. This is a one of its kind case, and so it's just it's complicated to try, and it's going to be complicated to overcome some of the interesting and unique defenses that the Trump team are going to come up with, and his associates are going to come up with.
Yes. Well, we'll see what twists and turns Smith has. So what have you got for Mar-a-Lago?
Yeah, so Mar-a-Lago, well, we'll just say, by the way, before we move on to Mar-a-Lago, I will just mention there's this whole thing about the protective order. I have talked about it on TV and so on, but I do want to mention there has been a fight over the protective order. One thing I think was very telling, Asha, before we move on, is the judge denied like a 3-day extension of time to respond to concerns about the protective order. That's a very good sign for Jack Smith trying to get his trial done quickly.
And the protective order, just as a reminder, this is about publicly discussing the evidence that Smith is handing over to the Trump team.
It's not even like, it's just revealing the evidence, sensitive evidence that's turned over.
And what kind of sensitive evidence would that be for the January 6th case? I mean, obviously, like in Mar-a-Lago, we have classified documents, and that has its own, set of issues and CIPA. Sure. But what are we talking about here that Smith would not want to be in the public sphere?
Well, first of all, let me just say this is a pretty standard thing that happens in I wouldn't say a majority, but a very large percentage of civil and criminal cases. Many or most of the cases I work on have protective orders. So, one company sues another company, you have a protective order because you don't want their sensitive, internal company documents,
right,
out in the public or whatever. And so this is pretty just standard fare. And essentially, there is a dispute over the scope of it. That's all it really was. That the Trump team was making it into, they had all this sort of hoopla that they put in their stuff around it. But it was basically just like, well, Smith wants to protect the interview reports of his witnesses. We don't think that should be protected. But everyone agrees that there's certain maybe personal information or private information or sensitive government information, like documents from agencies or something that we don't know, but various categories that both sides agreed should be protected. It was basically, though, to me, it was just a stall tactic on the part of the Trump team. Smith is like, I'm already calling them out on that. And I'm also calling Trump out, by the way, he also called Trump out on his like Truth Social, like, hey, I'm going to get you stuff, like where Trump, his vague, like, I'm going to get you. If you come after me, I'm going to get you, which was interesting. Before we move on to Mar-a-Lago, I will just say that, a lot of people are like, does this mean Trump's going to get thrown in the slammer during the pendency of the pretrial portion because he's truthing stuff out? The answer is no. He's got a First Amendment right to go, to say, rough things about Mike Pence. And the judge, because she's a pretty savvy, experienced litigator, is not going to get in the middle of that. But what she's going to do is get pissed if Smith keeps raising these issues and she keeps having to dealing with these problems. It's just going to inspire her to get this case done quicker. It's going to inspire her to maybe not give him the close calls. And it's a really stupid idea to be, if you're Trump, attacking the judge and everyone else.
Yeah.
Mar-a-Lago, I guess, regarding that, what happened, Asha, that I think is interesting. And I thought of you when it happened. I thought of Asha is, up until now in the Mar-a-Lago case, basically what's happened is kind of indistinguishable from a regular judge. it's almost like, you know how in Men in Black you have like, there'd be like a human being, and then like they would like aliens would crawl out of the suit or something. Like they were really like, there'd be like it looked like a human being, but actually there's like an alien underneath. So essentially, like Judge Cannon was indistinguishable from a regular judge roughly up till now. And then she issues this ruling out of nowhere where she says, there's this issue that no one's raised, neither party has raised, but I'm very concerned that an out of district grand jury is being used to investigate aspects of this case. This is like out of nowhere. Like maybe she heard it on Fox News, maybe she was like browsing the internet. It was just bizarro. And it made me think of the name that you give her, because it was just like literally out of left field. And it just reminded you that like, no, we still have Judge Cannon on this case. Like this is not just a regular judge.
Yeah, and I call her loose cannon. So she sua sponte came up with this allegation.
Yeah, I was going back and forth with the journalist trying to understand this. I'm like, you were in the courtroom. Did anyone like raise this? And he's like, well, somebody said something about it many hearings prior, but it had nothing to do with, the particular issues in front of her. And I guess I had always kind of calculated into my view of this case that Cannon was the judge. Like I was always not optimistic about this case going to trial quickly because it's Cannon and all that. So this doesn't surprise me, but it's just, it was just like out of nowhere. Like, hey, by the way, I'm very concerned that out of district, DC grand jury is investigating this stuff. Why is that? That sort of thing. You need to brief this. And it's like, that's not your job. Your job's not like to come up with legal theories for the parties to brief and consider.
Yeah. Like she's like doing her own little investigation or something.
She's like a research assistant for the parties. Or something.
It had just independently of that? Is that true? Is there an out of district grand jury that's still investigating stuff related to Mar-a-Lago?
There may be. I mean,
the fact of the matter is, for the case that Smith has brought, if it's for other people or whatever.
Well, who knows? I mean, we don't know all the details, but obviously aspects of the scheme occurred in DC, so It's not crazy to investigate it in DC. There's nothing in and of itself that's problematic there. To me, it's like, if I was a judge and a defense attorney raised this, not a judge, but a defense attorney, I'd be like, okay, well, that's interesting. Thank you for sharing that. It doesn't seem like, it seems a little early to be concerned about it at this point. Like get back to me when someone's charged and there's some basis to claim that it's inappropriate, but it's just, It's not ripe for us to be considering this issue right now because it just seems like nothing has happened. It's speculative.
Because I'll just throw out there as I'm thinking about it now. I mean, one loose end in the Mar-a-Lago scheme, at least one I can think of, is Cash Patel.
Cash Money Patel. And I suppose like he's somebody who could still be brought into that net at some point, right? Sure, absolutely. Well, he's the guy who allegedly, he claims, was there in the room when Trump made some sort of standing order or whatever it was, right?
Correct.
Yeah.
The secret, telepathic, unilateral, preemptive, irrevocable declassification defense.
He happened to be the only one
stupid
there.
Stupid defense. That was my acronym.
When that happened. Only happened to be the only one present during that key conversation. Yeah, who knows? But it's sort of bizarro for a judge to be concerned about that. But I have to say, because one journalist reached out to me, he's like, why haven't you tweeted about this or whatever? And I'm like, because it's hard for me to get outraged because it's sort of like, this is just what we expected, right? I mean, does anyone like surprised that
it's like she had like her own little temper tantrum in her court? And
it's just sort of like, this is what we expected. Yeah. This is like less crazy than anything that she had done in that prior case. So I'm just, it's like, okay, this is actually kind of mild for her. So whatever.
Yeah. She just fired loose cannon,
Yeah.
It's her again. Cannon firing. Yeah. So we'll see what happens there. It's been interesting that we have, that the focus has moved over. So much happening.
Yeah. 100%. 100%. So Asha, before we go, if you're watching the video, you can see that I'm leaning down because I have a little doggy who is leaning against me. He's very has been missing me this morning. But I do want to. I got to tell you a story about Henry. So in our area of the country, even though I live in a suburb, we have coyotes in our area, and that's actually a bit of a menace. Like people's dogs get attacked and killed by coyotes. So my wife has been absolutely afraid when she walks the dog of maybe she's going to encounter a coyote. What's going to happen to cute little Henry if a coyote comes and tries to attack Henry? And what we learned is when there was a coyote who encountered my wife and came and was interested in her and Henry. Henry is like totally street. Like he looks very cute. He's got beautiful, like poofy ears, but he learned a lot in the streets of Puerto Rico as a young pup. Mm-hmm. And so he's a little sato.
As young pups in Puerto Rico do.
Yes. So on the streets of Puerto Rico, because when we got him, like we had the Puerto Rican people told that were taking care of him, said that he was like a sato, a street dog or whatever, and this and that. And he had a little bit of some missing fur. So we weren't sure. But that coyote was absolutely scared to death of Henry. It took all of my wife's strength to make sure that Henry did not take down and do something very violent to the coyote. So Henry is the enforcer of our little suburban neighborhood and protecting us from the coyotes. And ever since that episode with the coyote, he stands watch on the landing of our stairs. He's like watching out to look and make sure the coyotes are not coming.
Oh, that's so cute.
He was very cute. In fact, that night he came by my side of the bed because he was very concerned that night. And so I had to comfort him, but he was like, he did what he had to do. Like he was very tough, very strong dog.
I love that. Well, my Pancake update is that, I was gone for almost 2 weeks. And poor Pancake. I mean, I had Kitty Concierge coming twice a day. And Kitty
Concierge?
Yeah, that's my cat sitter. She runs a company called Kitty Concierge. So she comes for, an hour twice a day and plays meditation music and plays with him. And, she has, catnip Saturday, spa Sunday. Like she's got different little activities that she does. So, he was in good hands, but he's such a social cat. He's a dog cat. So he's
a dog cat. Wait,
he's a dog cat because he just always wants to play. He's very social. He's learned to play fetch with hair ties.
He's not plotting to kill you. Isn't it like what most cats are doing?
No, he doesn't. He just wants to play. He wants to play and he wants to hang out. And he's learned how to play fetch with hair ties. He's obsessed with hair ties. And if you throw a hair tie, he chases after it and he picks it up and he brings it back. And then wants you to throw it again.
That's amazing. He plays fetch better than Henry.
Yeah. Only when he's in the mood, though.